4. Rather, an anomalous situation arises in the same, an impugned order is challenged from the single judge of the Guwahati High Court to the DB, from the DB to this honorable court. So the matter is pending even before the single judge. The issue, in essence, is whether a transfer can happen solely on the recommendation of an MP MLA. All other considerations only on a recommendation of an MP or an MLA.
Why are you mentioning it?
Yes, the High Court matter is listed now on the 18th of March. This judgment is binding on the High Court under Article 1.
What is 1
My lords, the interim order of this honorable court prevents the High Court from proceeding further. I am saying, my lords, we list this on the...
Interim order passed in this matter?
Yes.
Saying what?
Saying that...
Preparing for?
My lords, I am appealing for the state.
Why are you on this side?
My lords, I am...
Confusing the court as well.
Like...
Not allowed.
We remember this. Some Northeast state. Yes, sir.
Yes.
The state of we are considered the matter. We are not bound by that. My lords is taken up will come. Nothing. Anomaly would be, my lords, whatever it is anomaly, they have to comply with the order. They will be doing. It will be taken up on the day. There will be a conflict of judgment. This honorable court.
We'll examine it when it comes.
They have tried to bind.
Yes, for the court.
May it please the court, Mills.
Yes.
Whereas in this case, I've assailed the order of transfer that has been issued in respect of the petitioner. I've assailed this order on various grounds. The first ground is that this is a clear... The first ground is that this is a clear case of frequent transfer. The petitioner has been transferred 5 times in under 2 years. And the second ground, Millers...
Yes, are you very much?
Yes, Millers.
Yes.
Caveat?
No, Millers, notice has been issued. I filed my counter affidavit and
To file it.
Millers, sir.
So no dispute that within 2 years time posting. That is not in dispute?
On fact.
On facts, let us know. Yes or no?
On facts, no. Not on facts, no. But
Either he is very good or he is very bad.
no, I want to place certain things.
Yes.
Out of the 5 transfers, 3 of them were at his own request. Number 1.
3.
Number 2.
3. The last one also.
Millers, not the last one. But Millers, one more very important thing, Millers, which I want to place before Millers. On the last date of hearing, on 4th of December 20, order which has been passed. Millers, if we look at it, it does not transfer the petitioner from that post. The petitioner was supposed to be relegated to his substantive post. Millers, it wasn't. Millers, the petitioner, Millers, I just wanted to just make 2 things clear. The petitioner served as a process server. Because of certain exigencies in the state, and there were a lot of recruitments of direct recruits of subdivision collectors which were pending, some officers or some persons were allowed to look after. This is not a promotion. It is just an in-charge look after of that post. He was acting as a look after, in the capacity as a look after. He was looking after the work of the STC. It's
in addition or substantive order. Look only in that post, no, in addition to substantive.
Yes, absolutely.
Absolutely.
What is your answer?
No, yes. No, his substantive post was Jilada, and he will have to go to be promoted as an STC. On 11th November 2023, the order which has been passed is there were 91 new recruits of STCs because of the STC. Naturally, he would have to be relegated to his substantive post. Because of my Lord's order of 4th of December 2023, we have allowed him to continue on a look-after charge of the STC. Whereas this substantive use,
the persons who have now been directly recruited need to be adjusted because they have a right to that post.
Absolutely, my Lord.
So he is holding on to one of them.
Absolutely, my Lord.
So 91 cannot be adjusted.
No, yes, madam. He will have to be reverted back to.
Was he drawing a salary of his substantive post or the STC?
Minor, I think he's drawing. I don't have clear instructions, but I'm sure he must be drawing from the substantive post.
Substantive
He must be.
What you must be giving case.
Tell us.
Some states allow.
And Minor,
Some states allow.
Drawing your salary on the post of SDC or?
Post SDC, my lord. And not just that, my lord. The primary respondent is also serving in the same post. Look after. As look after Zilla Ram. They are in the same post, and it does.
Why did you file a rejoinder to this counter?
Because
There are these counters on record, you don't. On, say the public interest, respondent, state, where is this a transfer or? This request he had asked for a transfer,
Minor,
the first one?
Minor, I'll just get which transfer order was the. Yes, Minor, the December. Yes, this one. This one is one of.
7 January 21, safe in public interest. It doesn't say at request. So if you're saying so, it's not proven on the basis of the document or
It
record.
does not say so.
So how are you saying so? It says in public interest.
Minor, those are the instructions which I've written.
Your instruction can't be contrary to the record. It has to be in terms of the order. The order says with immediate effect in public interest, not at request.
Minors may kindly also see, it says LA. It is on a look after basis.
We are not going to look after the road. We are on your statement that out of 5, 3 he asked for.
Yes.
It's straight from the record.
Minors, I can.
So you are posted as a sub-registrar.
Yes, sir.
LA sub-registrar.
But salary as Ziladar.
Yes, sir. So how do you say that you're drawing the salary of?
well, it's subsequently the education has been transferred, and now he's drawing his salary as a look after SDC. Look after SDC.
So you accept if you look after, then you have no right to that. But yes, because you can say that you have been. There are posts available and you have been singled out.
Show us the second transfer order.
But the second transfer order is on the next
plate.
Please,
Suppose it is on his request.
Yes.
Then normally if his request is exceeded, then he should be given the normal tenure. Then why did you transfer him again?
No,
Accept it. If you accept on his, that means you accept the reasons given for requesting a transfer, then it has to be normally for a normal tenure. Normal tenure is what? Not less than
3 years at least.
3 years?
normal tenure, my lords, I completely bow down what my lords is saying. My lords, but the point is, my lords, he needs, now there are people who have been directly recruited to that particular
How
post.
did you make 5 transfers? Once transferred now to at least for 3 years, it should not have been tied. Now you can say last transaction maybe.
Yes,
then
sir.
why did you keep on transferring him?
You indulged him by acceding to his request.
My lords, I
Having
cannot.
indulged him, you can't just pick him up and throw him everywhere.
No, my lords, it's not a matter of.
We can't take records that there is any request.
My lords, I can ask for the state for the records, but the fact remains, my lords, this the petitioner is not at all.
Is it your case that no such person similarly situated to the petitioner has been holding this LA?
No, my
LA
lords,
business of.
no, my lords, I don't have proper instructions on that.
So then you have to come clean on that. Unless you come
Yes,
clean
madam.
on that, it cannot be
You can't pick and choose.
I completely bow down.
That-
I completely bow down.
You can't still twiddle your thumbs. that you will say, I'll say orally, they filed it late on before the last date of hearing, so I didn't file the rejoinder. We never heard such an excuse.
And when you accept that it is on a look after basis, then you don't have a, it is their discretion, they put you on a higher, that is a higher.
They moved you back.
Go to, you have a right, you have a lien on that, you have a basic right.
Please file a better affidavit.
Both of you get
If you don't want to file a rejoinder, it's your funeral. Take down. By the counsel for the respondent number 1, state of Manipur, and the private respondent number 3 have filed, saved their file counter affidavits in January 2024. Rejoinder thereto has not been filed by another counsel for the petitioner. If he seeks time to file a rejoinder, if the same is not filed within 2 weeks from respondent number 1, state of Manipur, then out of 5 transfers in respect of the transfer orders issued in respect of the petitioner, 3 orders were passed on the basis of on the basis of a request made by him. Relevant documents to demonstrate the same shall be filed by the by the respondent number 1 state. What else do you want to file? Anything else? It should also be clarified on an affidavit. The affidavit shall also clarify as to whether any other employees like the petitioner herein been look after working on a substantive post, but been assigned post higher to the substantive post on a look after basis. If so, whether they also have been reverted back as in the case of the petition. That the said affidavit shall be filed within 2 weeks with a copy to counsel for the petitioner.
Please.
Very
Well, I want to.
Please come. Please follow.
Because this is a case where the parties, this is an application that there is an interim, there is an order that has been passed by the US courts fixing the settlement between the parties as an award. Now, my lord, under that, certain properties have to come to me, part of the investments have to come
That
to me.
court is, unless there is an executing court here that can pass a mirror.
I can point out what happened here. No, what has happened is slightly different. My lords, the wife filed for a divorce in the Vermont court in US. Husband initially participated in that proceedings. Then what he does is he files an application before the party because the parties
Yes,
are
we are aware of those things.
Yes, my lords, just a minute, and I will be very, very brief. So, my lords, he gets an anti-suit, then he files an anti-suit injunction here.
Right.
Now, his application in the US gets rejected on the ground of the jurisdiction of the party from the Surat District Court. My lords, apropos to that, that order is presented there. That order is under challenge and it is still pending since 2018 before Gujarat Highcourt.
Come to the point. Your last order specifically, we dealt with an IE, we told the other side to get it.
Yes, my lord. On that $5,000 for 1 month.
I'll just straight away answer and very frankly because you said everything very clearly. But pursuant to the Vermont court order, $600,000 worth of my property was given to a sole debtor. So that entire $600,000 gone to her. I have not got anything. Now the question here is they are saying they themselves have filed a maintenance application pendent in the Surat court. Now they're inviting your lordships to give an interim order on. Have you already given 600,000? Let the Surat court decide.
Now, let me answer that question.
Yes, actually.
My lords,
It's still on 20th March.
my lords, can I just show that now?
The grievance is that you have not been heard.
No, my lords, my grievance is Surat court is just not progressing at all.
So that cannot be a ground for us.
My lords,
You can only request the court.
Yes, sir. Decided.
my learned,
I have always appeared, they have not appeared.
this, can I just respond to this now? Now, my lords, the court in US ordered $5,000 per month by way of maintenance, which he paid under the orders of this court. Then, after the matter came to be disposed of till February of 2000, he paid. He stopped paying thereafter. He has deliberately stalled the proceedings in Surat. Today, my lords,
We are only saying the next stage is round the corner. You will request that court to take up your application. And
It's only pendent and it can be decided.
What is the
20th March, Lord.
which forum?
Well, this is.
my lords, I would request that please keep this pending here.
This application.
My lords, then let me
Then there will be a clash. We don't
my lords, allow me then. Just allow me for a minute. Just in those proceedings, this court passed certain orders. And there are 2 facts which are very significant and I need to bring it to my notice. My lords, the husband participates even after anti-suit injunction, and why I'm saying that US court orders are now required to be implemented in the US, because at that time,
In the US,
in the US, my lords,
get it implemented there.
my lords, the properties are in India.
It's okay. There is a procedure of passing a bill.
My lords,
now
now-
the procedure. What
So
is
now-
the order, Mr. Arora?
So now-
who needs to know better than
Now, my lords, just
go to the executive court
half
and
a
get it.
minute, just half a minute, my lords.
Yes, please.
Can I just say where is the issue that comes up here?
Yes.
This court also allowed the proceedings in the US to go on, but that anti-suit injunction, which is pending in an appeal, despite the anti-suit injunction, he participates in the US with the consent order, brings the
And
children.
tell the appellate court about the expectation.
But neither the proceedings in the Highcourt are going on. My lords,
We have only an IA before us. You can't expand the scope of the president.
my lords, I am only saying that this court, my lords, just.
Only your IA. That's what
Yes,
says.
I'm only on the IA. Now, I'm only on
Your IA, similar IA.
Yes, my lords,
Family
please.
court, please get
Completely.
there.
Now, my lords, if my voice may.
And you want both the things to go together, we dismiss this application.
No, my lords, I'm not saying that. Would my lords please see what was this honorable court's order, please?
On an
Yes.
interim application.
My lords, no, in my substantive
That is why we are saying
petition,
that's not before
which
us.
is still pending.
That is not before us.
My lords, that petition, the rate petition, this application is that pending
Arora,
petition.
only an IA which is listed before us today. Let us not repeat ourselves. We have only the IA. Notice was
My lords, then can I request that my writ may be listed then together with this IA?
No, sorry. Under the garb of an IA seeking maintenance, we will not permit the
Then my lords may allow me to, then only my lords may give me that observation that I am entitled to execute my orders given by
What
the
was
US
the
court.
sign? Okay.
My lords, I can execute my orders.
Please first make up your mind what you want to do with the IA. Rest is your decision.
My lords, my IA is for my interim substantive, which I am not getting anything until now.
For which it is pending for the same cause of action and the same plea before the family court.
Correct.
If it is correct and the other side is not wrong, and your only grievance is that the application is not being heard to its full time, we can
So
certainly
can I just put it in a very small perspective and I leave it to my lords to take it from there. My submission is the matter in the Surat Parsi matrimonial court has been filed by him. Jurisdiction thereof has been challenged by me. And that is a petition pending before my lords, also the present petition in which this IA has been filed. Now, in the interregnum, the US court has already taken a decision where he participated initially and like no, my lord, so therefore, if there is a court of jurisdiction where he participated, has passed an order, and that I cannot implement, and he is insisting on
Mr. Arora for the last time. If there is a right of a court to pass a bill on the strength of a decree in your favor, which you know is a procedure recognized in the
will decide. My learned friend says it's coming up on 20th of March. Let my lords may fix a time frame. I have filed the
time frame.
proceedings.
It's coming on a date we are getting.
My lords, please, no, my lords,
That's what we can do.
would my lords have a look at the proceedings that I filed before that?
Ms. Arora, we are simply saying it's listed on the date. We will request the court to take it up. Take down. This application has been moved. Mention this application and say the petitioner wife has moved the present application. Praying inter alia for issuing directions to the Parsi District Matrimonial Court at Surat to enforce the directions issued by the Vermont Court at USA in its final judgment dated 2/7/2021 and direct the respondent number 2 husband to pay $5,000 USD per month as interim maintenance.
Interim.
No, that is an interim, and then there is a division of affairs.
In the course of submission, we are informed by Ms. Park that the other side has already, the petitioner wife, Ms. Baldagar has said the petitioner wife has already moved a similar application, right?
Yes.
For interim maintenance,
Before the yes.
which is pending before the Parsi District Matrimonial Court in Surat.
This also thing.
It's listed and now listed on, it's now
20th.
20th of March 2024. But in view of the aforesaid submission, we decline to entertain the present application. However, as Ms. Arora, Senior Advocate appearing for the petitioner wife states that the aforesaid application has been pending for long before the
3 years, 4 years now.
for fairly
Almost 4
before the district court and has not been decided. The district court is directed to take up the application on the date fixed and dispose it off as expeditiously
Yes.
as practicable. The present application is disposed of. Thanks.
My lords, I I can produce all the material and all evidence before the court.
ये बात they've disposed of.
My lords, that may be recorded. I don't want to come back in another round. My lords, I'm running pillar to post since 2018.
If you must have filed all that there, if you're not filed it, we are not filing. We are only saying they must dispose it of on 28.
My lords,
Item 3 and 61.
My lord, please. Several is already.
23, 15919 of 23, right?
Right.
1613 of 23, 1610 of 23, similar orders. This must be. 3 and 61.
Item 4.
Now, explain the delay in this case of 1,260.
Your Lordship, delay has been explained. Your Lordship,
Let's see, what is the explanation?
Your Lordship, kindly turn to page. Original petitioner Ram Kumar has expired in the month of September 2020. Your Lordship, this file has been entrusted to one Mr. N.P. advocate. Your Lordship, he has been preparing the SLP, but he could not file the SLP. And during the COVID time, Your Lordship, in the month of 2021, he has expired.
We are sorry. The impugned judgment is of 3rd of December 19. Nobody dreamt of COVID at that time. So to say that COVID happened and the council expired doesn't explain the period from 3/9/2019 onwards.
Your Lordship, I brought on before Your Lordship because instruction from
Sorry.
instruction
By the Commissioner mentions here, IA number 62384 of 2024. This court is not inclined to condone a delay, an excessive delay of 1,266 days in filing the presidential fee. The present petition is dismissed on delay.
Your Lordship, I am altogether on some different aspect, Your Lordship.
You can't be on any aspect except limitation. Your story starts and ends in limitation. Next.
Item 5.
Here I'm only.
If the bus suddenly breaks, it's not a delivery, no. And somebody will wait passenger, straight away the bus driver will have to pick up that passenger.
And please, my lords, can you see the above page, my lords? There is a spot.
To see the photographs. We are asking you, there must have been a proper mechanical report. Where is the mechanical report? You can't rely on photographs for us to check.
My lords, I'm relying these photographs because of the reason is, my lords, showing the exact.
Mechanical report is by a technical expert. Let us see
Just
the
because hitting from behind will not make
That's not enough.
My lords have asked the question in behind because my lords first come from this side and they are moved immediately behind the back. That's why I am to show that this is not that I am stopped immediately. He is supposed to break the immediately to stop the accident. He is supposed to avoid the accident, but he is not done. And accident taken place in the midnight. That is my one. Second is, my lords, that 20 lakhs announced by the Honorable High Court. My lords, the can see the
What? That's 15.
that
16 lakh 15.
my lords, tribunal was announced to 61 lakhs.
A tribunal has awarded
61, my lords. High Court has announced to 81. And exact, I'm leaving about other announcement. Only actual on the salary basis. 61 lakhs is tribunal, my lords. And kindly see the tribunal was going.
Formula, I adopted the formula. According to formula, where is the error? Except for you say contributory, what else is error? The amount you cannot challenge. Amount is as per the formula.
Please, ma'am.
Now you say because of contributory, that is another point, nothing to do with the quantum.
I mean, their salary secretary, which itself is contradicting themselves. So kindly see the High Court while tribunal while relying on the salary certificate on page number 20. Their own salary is contradicting, and on the basis of the income tax, they have the income is assessed. My lords, the 4-year incomes and different income taxes is showing that thing. Kindly see the page number 90, para 20, my lords. I read that para for me. Please, my lord. As rightly suggested by the PW1 Exhibit P1 page would be disclosed that the March 2013, 29,981 only is added to the account of the deceased toward the salary on 33,2017.
Page 9. Yes.
Before.
Am I read again, my lords? Starting. Yes. No issue.
Yes.
Yes, my lords. Para 20, my lords.
Yes.
as rightly suggested by the PW1 Exhibit P10, page 5, disclosed that the March 2013, rupees 29,981 only is added to the account of the deceased towards salary on 33/2013. The same document at page 8 would disclose the salary of March 2013 is 40,706. There are two entries in the respect of the salary of the deceased in a single month. Petitioner's own document is contradicting. In this background, considering the qualification, post and company of this criminal assesses the income of 30,000, my lords. That rightly, I can see the High Court, my lords, without there being a reason that is taken.
High Court has held this salary to be how much?
Please, my lords. And High Court considered on page number 13, my lords.
What is the amount High Court has considered?
High Court would consider that 4,16,000 around comes at 39,000 rupees, my lords.
39?
On page number 13, my lords. 13, my lords. It's taken all 3 years income tax. I read for please, my lords.
Yes, 13.
2012, 13, 13, 14, 14, 15, and Exhibit P is 26. The income tax return of the assessor in the year 2013 filed and 13/5/2012 discloses the annual income of the deceased to be 4,16,859. And the income tax return of the assessor in the year 2013-14 filed and 13/5/2013 discloses that the annual salary of the deceased to be 5,53,398. The income tax return of the assessor in the year 14-15 cannot be relied upon. The same has been filed subsequent to the date of the accident. The aforesaid returns are further corroborated by the payslips of the deceased Exhibit 227. My lords, here my humble submission is, my lords, the income is not a fixed income for it. Every year is fluctuating. That's why the tribunal was taken in the middle, which was one of the middle, and they come to the conclusion that 30,000 has to be taken as an income and calculated, and 61 lakhs is granted, man. High Court only had taken 1 year before. His income tax itself is fluctuating. In this situation, my lords, the middle as the portion which was that has to be calculated.
What was the financial year for which
the accident has taken place on, my lords?
The tribunal has taken?
Tribunal that the year of please, my lords. The tribunal has taken the year 2013, my lords.
Income tax return for assessment year 14-15 will mean income tax year 15-16. So assessment year is financial year 13-14.
13-14.
The accident took place in 6/4/14.
Yes, my lord, 14. Immediately, my submission is that 5 years income tax is filed. Middle one has to be taken as the tribunal has taken the rightly middle one. 2013 income tax, my lords. And the High Court was taken immediately before one. But same every calculation from the his income is 24,000 to 39,000, my lords. In the year 2014, his income is 24,000. If you calculate it, divided into that, has to be taken from the submission. Please, ma'am.
This will be mean.
Salary can be fluctuating in the sense you may be right, but when the annual return shows
Yes,
5,53,000,
How do you
then
overlook that?
salary may come in tranches. It may come 15 days, one lump sum, another after that, maybe carry forward to the next month.
Please, ma'am.
Just because one entry, only 2 entries in 1 month and half a year, that is not. Income tax return is more reliable than what is reflected.
Yes.
You may sometimes get something in cash also.
Yes. My lord,
Please disclose that.
Yes, that we are not taking into consideration assessment year 14-15 because that was filed subsequently.
Subsequently, and
yes, that's correct. That's correct. High Court has done it.
but
The
this is
subsequent.
13-14 is 5,53,000. You
Yes,
divide it by 12.
Yes, my submission is that on the basis of the dividing it, my lords have asked the question that it has to be taken as the entire amount. Is you are right, my lords. This 24, 29 as I divided into that total amount. That is not that I am salary exactly. I am
Divided 5,53,000 minus the perks and all.
Yes.
It is taken as 39,000, say 40,000.
Yes.
12 for that will be 4,80,000. As it is, the grace of 80,000 has been given.
Yes, my lords.
If it has been reduced, what is wrong in that? Income tax return is more reliable. You would not have,
Yes.
you would not have paid more tax.
Yes.
You are not earning.
I am pleased, my lords. I am not saying that income tax return is wrong. My saying is everywhere fluctuating. That is not the same. It's coming in the middle.
Tax has been paid on.
For a year, if you earn, then it has been.
But you started off on all this without explaining the delay of 455 days.
This is delay is there.
Both delay also.
Kindly, my lords, kindly, because it's a department, my lord, that's only delay. Dismiss on merit.
Know the delay and delay in filing and refiling, dismiss it on merit.
Highly appreciated. Highly appreciated.
I can take
Yes, 6. Somebody here? Sorry.
Item 7. That's a beautiful petition.
Yes.
My defense is like it's a school bus. The students comes to Malwali, that is in Mandya. So outside the government was to ply the bus in the district of it's a specific plea in a written statement, Malats.
How do you demonstrate? Your plea is only a plea as long as you are able to demonstrate. Show us plea.
Malats, in the written statement at page 55, we have specifically taken this.
How did you demonstrate that? That's only an averment.
It's our driver's deposition, which has not been rebutted by the other side, Malats.
Driver's deposition advice. If there was a herd of elephants due to which there was a detour, a local police would be the best person to indicate it because the traffic would be diverted for everybody on that day, on the date of the accident, right?
Let's say, apart from this,
Without that, you say it was on a different route for justified reasons.
that has been believed by the tribunal almost. The tribunal accepts this rationale that there was a herd of elephants. Because of this, the bus took another route and had to enter into Malabali Manals.
That's fair. Come to parent 26. That's what you're referring to, page 70.
Indeed, Manals.
Right? That is where the issues are. Driver being scared of elephants was returning back, entered the Malavali road.
Correct.
He was more concerned about. We understand there is concern. Okay. Was he crossed on this? Let us see that. You're saying the driver was not crossed. Show us deposition. Have you filed it? No.
No, deposition is not filed, Manals. I'll place it on record.
Is that your only ground?
That's the only ground, Manals.
And the deposition, maybe should notice.
Manals, I'll do that, Manals.
7 and 62 issue notice. Now, do you want the notice to go to the deceased also, only to
No, Manals, only to the insurance company. Because it's between us now, us and insurance company.
at the request of Congress? This happened to the payment.
Manals, they have paid the money, they have filed the recovery. Yeah.
Further orders, no coercive steps shall be taken against the petitioners by the responsible one insurance company for recovery of the amount is in favor of the claims.
Well, it's same order in 62.
Both matters.
Applies to.
But in the meantime, the deposition of all the witnesses shall be placed on.
Manals, applies to.
Delay, how much delay?
Manals, there is a delay. Manals. 300 odd days.
Don't delay. Okay.
Item 8.
Insurance policy is on record.
Policies are only permitted to recognize case insurance policy.
All the relevant documents filed in place, we might need them.
Please let us back to appear for the petitioner. VR is on.
Press Club of India, you are completely broke.
Well, we don't have that much money to.
You don't have 10 lakhs to deposit in court as an interim measure. The court must have quantified it on the basis. So we understand what you're saying,
Please, ma'am.
sexual harassment.
Please, ma'am.
We understand that there is a criminal case in which he has
Please,
been
ma'am.
indicted.
Correct.
But that money is not being released to him.
I mean, because then court.
That order is only to deposit.
Correct.
Then,
I mean, they find it.
interim order.
And it's a good case where I will succeed. Then,
It will be up
well,
to
we are.
you're saying. We are only wondering, this is not a case where the amount is being directed to be released to him.
Correct.
It's a case where it has been directed to be deposited.
Well, we are in some difficulty. That's why we are choosing this way. Otherwise, we could.
Staggered payment. You were in difficulty. You could have said, I'll permit me to pay it in a staggered manner. Deposit, not pay. That would have solved it. You can even do it now. Why are you here? It's an interim order.
Well, this is an interim order. We are difficulty. We are day to day. We are. Then will give us liberty to say.
The counsel for the petitioner seeks leave to withdraw the present petition while reserving the right of the petitioner to move an application before the High Court, expressing its financial difficulties and seeking seeking a reasonable time to deposit the sum of rupees 10 lakhs in the registry
Please.
of the High Court.
I know.
Has paid for his started application.
While delay
Petition
continues.
is disposed of along with the pending application.
While delay will be controlled. 100 days.
That's okay. We are disposed.
Hello.
9.
Yes, Naik.
Ladyship, this is a matter where we couldn't appear in the High Court.
Why couldn't you appear? That's the point. High Court, don't blame the High Court. You don't appear, sit and twiddle your thumbs. What does the High Court do?
Milords, it could have been dismissed for non-prosecution. Milords, we would have filed the restoration application.
Why? Why should it be dismissed?
Milords, not on merits.
Why should it be dismissed for non-prosecution? Why? How many times did you not appear?
First time. And Ladyship, this is for non-prosecution. The dismissal is on merits, not on non-prosecution. That is the only thing, because the High Court ought to have considered, at least heard us. Ladyship, that's the only thing, that we may be heard.
Not the delay issue notice, or the respondent or the petitioner filing process, we stand it already. Is there any execution now?
Ladyship, I am not aware.
Do you not pass any next?
I don't have. Ladyship, execution is there. Yes. Let me just interim order.
Where is that?
Ladyship.
You are asking for interim relief. Is there anything you have?
Interim and there. Yes, interim is there.
May have. Is there anything for enforcement?
For the execution, I have no instruction.
No orders. Next.
No instruction.
Issue notice on interim. Okay. And the counsel for the petitioner states if you wouldn't have withdrawn it. Yes. Nine.
Well, I confess, my lord, this was not the right submission to make before the High Court. To say that the matter is. So what I'm asking, my lord, is I will go back to the High Court.
Amazed.
I'll go back to the High Court because my submission is really that the directions this court, my lord, but the cat wrongly held, my lords, in my respectful submission that the matter is attained finality because of the earlier round of litigation between when I was not a party.
Whatever it is.
So I'll go back, because I'm just saying, well, I will go back, kindly permit me to withdraw and go back.
That concedes at the outset that the submission made on behalf of the petitioner before the High Court for permission to have the matter placed, to take the matter directly to this court for consideration was improper. And such a submission ought not to have been made. Submits that date to withdraw the present petition. The 11 and 15 notice of the pleas on the merits of the relief prayed for. Now we are not reviving that petition.
Because if I came to the High Court against the order of CAT, so I'll not be able to file a fresh petition, they will say.
And it's granted relief to file a fresh application before in WP number 4, in the writ petitions filed for taking up with a request to take up the matter on merits, take up the matter for a decision on merits. That leave as prayed for is granted, petitions are dismissed.
And all my contentions are left.
Post on as not pressed along with the pending applications.
I'm very grateful.
I can file.
SLP spelling is the related judgment, page 73.
Just 1 minute. It's relied on this to that same match.
Yes, page 73.
Yes, SLP 159117 of 2023, right?
Yes.
Order of 18/8/2023. Right. Next.
Probation.
Item 13 and 66.
Well, these are the probationers matter. Let's notice and tag. These are the
Same Punjab.
yeah, same, that's right.
How many are coming? You're inundated.
Because I quite see, but really speaking, it's a legal question. Everybody
Yes,
has.
but then whatever it is, you are the ones who are the petitioners. Can the
Let it decided in one case, they will follow. All tagging.
I'll try and see what we do. I appreciate.
Yes,
We take appropriate.
36.
I'm grateful.
Orders, notice and connected matters to be tagged. Next.
Grateful.
14.
Yes, 14. Yes,
I am clear to state, Lordship.
stated to reserve.
Yes, Lordship.
Same orders as in the other matter. One of these matters came up on 4th of March before us, SLP's bill diary number 51419 of 23. Prakash Ranjan Naik
Lordship.
was the AOR and the petition delay was known. Then we had passed an order.
512.
Yes, and we have disposed it of. We are also, how old is the child? 1 year, 6 months, same.
Lodge.
Same orders. Take down the orders as passed on 4th March 2024 in the present matter as well.
27 2 also. There's 2 orders.
On 27 to 2024, we take them. Note down the
512.
SFP diary number 51260 of 2023. I have this one here if you want to complete. Next, the dismissing letter condoning the legal.
I don't obtain in this matter, Niyojan. It is my request before the court to get a physical conciliation proceedings with us because parties are so far connectivity issues always there.
Sorry, this
Yes.
activity thing won't engage us any longer.
So that has been dismissed, madam.
That's
That has to be considered.
that on merits addresses.
This is the only point.
This is not engaging us at all. It's a misuse of the process.
No, on 16/1/10/23, the court observed that the parties themselves are not
Yes.
inclined
That's right.
for reconciliation. So why?
It is not the wife. It is not a wife. It is always the interest from the husband side.
So
Who did turn up for the?
either of the parties, if they are not wanting, then can it be forced on the other side? Both have to agree for
We are sorry.
Though one party doesn't agree, connectivity is not right.
Only the last request that there is a cost has been imposed, that should be.
That's right, cost should be imposed. What is this misuse of the process? That's why we said.
It is not that way, Mrs. Always,
You can't log in, what is this?
it is always on that.
On the cost, we never interfere. Don't even make such a request to this court. Sorry, you want to waiver, go to that report. No merits dismissed, no the legal.
How much is the cost?
What's she doing? Besides not appearing in PCs, what is she doing for a vocation?
She is a student, she is doing MDS.
Sir,
Student, MDS, Master of Dental
so
Studies.
she is a professional,
Professional, she is studying. Yes.
she must be working by now.
To my last.
Working.
Yes, yes.
No, how do you say it's working? It's a full-time course, MDS.
And yes, she is doing. Earlier, before that, she was working for some time. And marriage is a 9-year-old marriage, and all the turbulence is beginning. 2015, they got married.
We decline to entertain the present petition. On merits, at this stage, the counsel for the petitioner states that at least the cost of rupees 25,000 imposed on the petitioner may be waived. Imposed by the petitioner under the impugned order may be waived. So the petitioner moves such an application for the Highcourt. The Highcourt is requested to consider the same in the light of the submission made in the application and pass appropriate orders. That's a broad enough bit.
I'm grateful, ma'am. So nice. Item 16.
Maintainability. So go to the High Court misconduct. The reversal of Sombo's judgment will come in your way.
Your Lordship, actually, I have checked that there was and if I go to National Commission straight away,
You can't go to national. You're coming through DC, DRC, SC, DRC, route to SC. Or you have to go to the High Court. Universal Sombo's judgment comes in.
okay, I was.
And it's before the High Court.
I was
The judgment is 2023 SEC online, Supreme Court 877. Go to the, permit the council to approach the High Court for it. Thank you.
Item 17.
Yes,
Same orders.
yes. Was my request?
550 days. Hang on. Hang on. 550 days.
Yes.
Was Sanjay Gopinath also had covered the delay of 530 plus days?
Was may have my confirmation of the application to serve explain my test.
That is secret.
Yes. Yes.
What do you have to say?
No, we were trying to settle the matter.
That you in any case after
In all these cases, we were really trying to settle the matter. Then my knowledge was aware that the promoters were behind in
You
advance.
are the promoter of a pretty fairly big company. Why should we give indulgence to you?
550 days.
Why should we give
So
indulgence?
my condemnation of delay was.
We dismiss it on condemnation.
No.
We don't take it.
No, not.
It was
What
actually.
is paid?
Because what happens is that when we're trying to settle the matter,
You don't give it a deadline. It's as vague as it can.
You know the time is taking
because
for you.
it was cost, this is a meritorious matter.
No merit. You just
Some cases business cost.
Because in
Cost failure.
one case it's just slipped and we should.
But what happens is that this issue is pending before your lordships. If we dismiss this matter,
Come on time, yes, here.
what all the other
Why would the others take advantage? Dismissal on dealing. We actually cite by the explanation offered in the application, mentioned the application for honorable delay. Therefore, declined to condone a delay of 530 days in filing the accompanying appeal. The application is dismissed. As a consequence thereof, the appeal stands dismissed. Thank you.
may I just
In some cases, some of the not. Thank you.
may impose cost on me. This is actually a very
No, but I think second thought about if you wanted notice. What we've done, you're not pointing. Let it come again, but now no.
Follow the order, but we'll be strict. Thanks.
So the parties were trying to settle. Because I think behind the bars.
The quota may have been behind the bars, but 530 days he was behind the bars. Was he drafted? You are
Yeah,
legal.
3%
You are
doesn't.
legal.
3% interest,
Rather than file a bit affidavit for
We are not
condemnation.
going to do that.
This issue is
So
before
sorry,
your
I'm
lordships.
passing it on merits, only on legal. So it's not going to be taken as an example by anybody else. So sorry. Next please.
I committee.
But we have filed a 32 petition for the reason that brought in respect of, this is what the state of, what's the name?
State of Bihar.
Bihar, in respect of Withdrawal. In a somewhat similar situation.
Point it out to the state head.
No, there is judgment of this court.
Maybe point it out to the state head.
Well, the High Court can't question the judgment of this court.
Maybe not. But you don't come here directly.
No, that's just very, they have to take that route. No, I am saying that the judgment of this court has ignored a statutory notification. So that means it has to come. How come not the High Court look at it? It's a
Come to proper time.
High Court can give a foundation for you. Not the judgment is a detailed judgment. It's not a short order.
Okay, come to proper. All that we are saying is.
And even if there is a judgment, then you have to file a review for that judgment. We are not a party. Not. I can't file a review.
Okay.
This is a different state, that's a different state. You are right. Against me. You are right. Then you have to file a petition first. As a one way, you cannot take a different view just like that. So there are only two ways now. One is I file a writ, I have it dismissed and I come here. That is one way. Just go directly.
That directly we are obstructing.
And not I will show the record.
Will permit you to approach the High Court or we dismiss.
They only say one thing. The lordships can record a line saying that I have come here directly for this reason.
We don't need to have petition, says.
I have filed not that judgment also. Yes. Yes, very good. I withdraw it not.
Very, Mr. Rotary Senior Advocate, very for the petitioners, submits that on instructions that the petitioners may be permitted to withdraw the present petition filed under Article 22 of the Constitution of India, while reserving the right of the petitioners to appeal to the High Court of Patna, right? For appropriate relief.
Good.
This is prayed for in the writ petition.
Good.
You guys pray for us. Also,
Sure.
next.
Item 19.
Yes, please, thank you.